number 44, American Standard. Counsel, you want some rebuttal time?
4 minutes, if I may, Your Honor.
4 minutes. You've got it.
From strip searches to contractual indemnity.
Yeah. Okay.
The issue for the court to resolve here is whether my client, Oak Fabco, assumed liability to third-party tort claimants injured by Kewanee boilers sold or installed before 1970 under a specific 1970 contract. Two things at the outset that are not an issue. One, however the court resolves this issue, it does not affect the separate issue of whether American Standard still bears liability to third-party plaintiffs in other cases. I don't think anybody disputes that. The second thing that I don't think is disputed here is that whatever the court does here should not affect the issue of whether or not American Standard is entitled to collect from Oak Fabco assets on any claim or debt arising under the purchase agreement. A bankruptcy court orders decided way back in 1993 that that cannot be done. And I don't think that American Standard here professes to try to alter that in any way.
What's really going on here? Is this a claim on the insurance proceeds in substance?
I'm not sure. I'll tell you the way they framed it. The way they framed it, I believe, is that if they get a declaration here, it will encourage more third-party plaintiffs to go against Oak Fabco instead of going against American Standard, and in that way help to alleviate the pressure on American Standard and third-party claims. Your Honor obviously should ask opposing counsel. That's been my understanding. They've never said flat out, look, all we want to do is get a ruling that will then walk in and use in an effort to go against the insurance proceeds. But I'm not going to rule that
Well, they want
out.
an interpretation.
I don't represent the insurance carriers.
They want an interpretation of the contract and of the language of the contract, correct? That's what they're looking for, is an interpretation of the contract.
Absolutely. Between them and us,
right.
Let's finally resolve once and for all what is this provision.
Okay, and whether there could be potential liability for contingent tort claims down the road. So that's what's at issue here. So don't we have to look at the language of the contract?
Correct.
And the intent of the parties?
Absolutely.
So let's do that.
I apologize, Your Honor. Yes. Both sides have said contract's unambiguous. We say, gee, that's funny. Contract that's unambiguous says existing and outstanding. Hasn't this been decided before?
What does the clause of the contract mean that says other claims and complaints arising out of or in connection with any products manufactured, sold, leased, or installed by Kewanee on or prior to the date hereof? The on or prior to the date, what does that refer to if it's only existing?
I apologize. I can tell you how you can interpret it, but the important starting point is, can it be interpreted to fall within the meaning that we're giving to existing and outstanding? That's the question. Because there's no question that unambiguously existing and outstanding is the determinative phrase. But to answer your, if I may, to give a narrow answer, once we recognize
outstanding can mean boilers that were sold or installed or leased somewhere else.
I don't think so. I think we're talking. Remember, we're talking about a liability that's existing and outstanding, right?
Okay,
Not a boiler that's existing.
So what does on the date prior to refer to?
That can easily be interpreted to only have to do with basically contractual relations with customers. In other words, once you start with the premise that it's got to be existing and outstanding, we say that in a tort context, this has already been decided by this court back in 1984. If we accept that that is still what it means, and then we look at the provision Your Honor just read, we say, well, boy, I have no problem reconciling that with this provision, because this provision can have to do with relations with customers, having to do with a defective boiler, which, by the way, that makes perfect sense, because remember, we took over their entire business. So if somebody's got a problem with a boiler and they want it repaired and they want to return it, it makes perfect sense that that should be our right.
Suppose a boiler was sold the day before the business, before your client bought the business.
Yes, sir.
and the day after you bought the business, the boiler blows up.
Yes, sir.
And the customer calls you and says, fix the boiler. You have to fix the boiler.
Absolutely.
And the guy who's hurt when it blew up sues, and you have no liability?
Absolutely. That's exactly what it means. That's exactly the way it is.
Unambiguously.
If Your Honors want to send it back on ambiguity, I'll be happy, because the only other evidence we have is that letter that we put in evidence that's at page 281, where prior to the closing, American Standard writes to Fabco, and forgive me, it's Kiwani, then we'll treat them interchangeably. They write to Fabco, and they say, you know what, the final agreement we're going to prepare in the way we prepare most of these. We're selling assets all the time. We're going to prepare a contract law along those lines. So they're the drafters.
Why couldn't you argue that in the hypothetical case I gave you, where the boiler failed after the sale, why couldn't you say to your seller, oh, that wasn't existing and outstanding, no injury had occurred?
Well, I'm a lawyer.
No breach of warranty.
I'm a lawyer, and yes, I can argue that. But I am here defending the third-party tort claims, very distinct class of cases, where we've got a 1984 decision by this Court that says, here's what it means in the tort context.
Is that a different
And I find that
provision?
easily
Is that a
distinguishable.
different provision? Is it the exact same provision?
I'm sorry.
Grant Howard is what you're talking about, right?
Oh, it is absolutely close enough. The key phrase in
Close
Grant
enough. Is it the same?
is it literally the same word for word? No, it is not.
Okay, what's the difference?
Absolutely. Well, the difference
this one
is
broader?
barely.
Is this a broader
the
from Farrell?
commitment. The difference is the word commitment. This contract has the word commitment as in addition to obligation and liability. We don't, and we say in our brief, I'm sorry, commitment doesn't turn Grant Howard on its head. You still have a situation where, as of the closing, you have double contingencies. And double contingencies makes this something that is not existing outstanding. Double contingencies means, first, we don't even know if somebody's injured. And then second, we don't know if they're going to have a successful claim. And Grant Howard says, if you got a claim, if you have the right to a claim, then you got a contingent liability, because there's only one contingency. If you got more than one contingency, forget it, it's out. And Grant Howard's not alone in that. As Your Honors know from the cases we cited, you can go back to 1880 in the state of Maine, you can go to Kansas, you can go to Missouri. This vexing question of contingencies versus contingent liabilities has come up for more than a century. And the courts have tried to step back and say, it's almost like an inference on an inference. You can make an inference, but if you're having to make an inference upon an inference, the court draws the line. Here, if you've got a single contingency, okay, a single uncertainty, then you have a contingent liability. If you have multiple contingencies, which we'd have here, then that's over the line, that's not covered.
I thought Grant Howard was based on the fact that the injury in the tort action accrues at the time the injury occurs.
That's the point. As of the closing date, there isn't even an injury. So forget about there being a successful claim. There isn't a claim.
I'm just confused by what you mean by multiple contingencies. I thought we were dealing with the point of accrual in Grant Howard.
And here's what I'm saying is the multiple contingencies. On the closing date, if you don't have an injury, then you have double contingencies. The first contingency is anybody ever going to get hurt? The second contingency, which Grant Howard talks about, is will it be a successful claim? First, you have to have a claim. Then that's a contingent liability, but you don't know how it's going to come out. You just don't know. In other words, once I have a lawsuit, I don't have a liability. I have a contingent liability.
Does it matter the nature of the injury, like asbestos here? Does that matter?
We've acknowledged that there's obviously a difference with latent injuries. Okay? There's no getting around that. That in Grant Howard you had simple, old-fashioned, something broke.
Well, that was going to be my next question.
Absolutely.
How do you deal with it where it's over a period of time?
And we have said that you can look at the Grant Howard language and it still provides all the guidance,
Yeah, but
which
when
is
do
you
get-
look at the
When
accrual.
do you have the injury from asbestos, let's say, in this case?
I
When
think-
when do you
Well, there's not in this case. That's exactly the point. That's exactly what is so very wrong with the way the court handled it
We
below.
don't have an injured
There's
plaintiff.
not a single answer. You have to look at the plaintiff, and you have to say, when is that plaintiff injured? If the plaintiff is injured by asbestos in Montana, frankly, the result may be different than if the plaintiff is injured by asbestos in New York, because you've got to look at the applicable law.
What about New York? Yeah, tell
I
us.
thought this contract is
Well,
under New York.
in New York, we'd say if somebody comes in with a lawsuit now, I mean, we have to be talking about specific lawsuits, all right? So if somebody comes in and says, here's the third-party claim, they just filed suit, then we respectfully submit that you look at that claim and you look at the accrual based on the statute of limitations that's now in force under 214C, discovery rule, which not every state has. But it would be the earliest point at which they'd have a claim.
This is more
That
like
would
a
be the accrual
declaratory
date.
judgment between insurance carriers. That's what this reminds me of. You know, you have a separate underlying personal injury action going on, and then you have two carriers who are
Right.
trying to decide who's liable here, and that's what this reminds me of. So, I mean,
I can't quarrel with that.
I thought this contract, though, provides that it's governed by New York law.
Yes, no question. Well,
So why
there
are
is
we-
no question.
Why are we
that-
talking about Montana?
Well, because we would respectfully submit that the interpretation is just what is an existing liability. The answer, when somebody basically has a claim. Under New York law, that means when the injury takes place, right?
Well,
If you go in-
under our continuing harm, couldn't someone claim here the asbestos injury occurred from the date of the first exposure?
Well, there used to be the rule that was abrogated by 214C, all right? And 214C applies, and then the test really is when did the person discover or have reason to discover? Right, exactly. The injury. That becomes the marking point, the date of the injury. That's the time when they can first walk in and say, I've got a suit, and prevail.
But that wasn't
One of the
that wasn't the law in the contract.
No, it wasn't. But
In
one
fact,
of
it was quite the opposite.
it was a regret. Well, I'll say it. Yeah, it was a regrettable law because what you had was an exposure rule that presupposed an immediate injury, even though there was no compensable injury. I mean, that's the reality.
so
There
if
was
you're
no
looking at the
compensable injury.
intent of the parties.
And so that was remedied as of
Yeah, but I was going to say,
1986.
that if you're looking at the intent of the parties, this thing was executed in, what, 1970?
But we're supposed to be looking to the question of, show me the claim, and we'll decide who's got the claim.
Well, there was
So
much
we
greater
respectfully say, you
exposure.
show me the claim. If I've got somebody who had to rely on that rule, that's fine, but that's not going to be the rule that's going to be applied now, and that should govern.
Well, then I would assume that there'd be greater exposure to liability for a contract that was formed in 1970 as opposed to a contract that's formed now in 2010, where the statutes changed, we have, 214C, et cetera. I mean, you could possibly use the same language and come out with a different result. But you had lawyers on both sides, I assume, sophisticated parties, who knew the state of the law and the state of the tort law at the time.
Well, obviously, we respectfully submit that that's not the way it ought to be resolved, and it should be resolved case by case. When a case comes in, you look at that case and analyze, all right, when did that person's injury occur?
When you look at the deal that the parties made back in 1970,
Yes, sir.
you bought the whole boiler business, didn't you?
Absolutely.
And they didn't keep, receivables from before a certain date, or so we didn't keep these accounts.
I think that's right.
As a business matter, did it make any sense for them to keep potential tort liabilities when they weren't keeping anything else?
Well, it's not a question of whether it makes any sense. It's a question of how the contract was finally worded. And it says existing, all right, it says existing outstanding.
If we should somehow find this less than luminously clear, are we allowed to look at the business reality against which they were negotiating?
Well, if you're going to do that, I would ask you to look at the letter as well. And the letter indicates that this contract was no doubt drafted along the very same lines that American Standard always drafted their contracts, and therefore We got an inference against the drafter. I mean, after all, the one thing that Grant Howard says that I think is very important, I mean, it's sort of the policy underpinnings of this, that you don't have a contingency liability when one of the contingencies is unpredictable event that an injury will occur. And if you don't apply it that way, the purchaser will be unable to meaningfully limit its liability. What the other side is saying is, congratulations, you did buy the biggest pig in the poke that you'd ever asked for, even though it says not just any liability. I mean, after all, they could have said any liability, past, present, or future, right? Existing or not existing, fixed or contingent. Could have done that. They didn't do that. Fixed or contingent, existing and outstanding. And that, we'd say, is you know, a critical aspect of all this. If there are no further questions on that particular issue, I'll briefly touch on the whole res judicata collateral estoppel.
Very briefly, Counsel, your white light is on.
Yeah.
You'll have rebuttal, but go ahead.
Yeah, and I'm not even sure I need to. I mean, I'm ready to take these on one by one. I'm satisfied with the way we've briefed it, and I'll wait for the rebuttal.
Good.
Thanks,
Counsel. Counsel?
Good afternoon, Your Honor. My name is Yvette Harmon, and I represent American Standard. What you have before you is an interpretation of a 40-year-old agreement between the two parties involving a business transaction exactly as it was described by Your Honor, by Judge Smith. Excuse me. The contract here is drafted in precise language in every which way to make it clear that there was a full and complete assumption of all liabilities as to obligations.
So why are the words existing and outstanding in there?
The words existing and outstanding are in there to reflect obligations, liabilities, debts, and commitments. Existing and outstanding at that time was the obligation of the seller as a manufacturer of boilers to be responsible for design defects, breach of warranty or merchantability, and a failure to warn. Exact obligations that OFABCO admitted
Suppose the agreement had said existing or which may hereafter come into existence. Would that change the meaning of the contract in your view?
Yes, because what the contract did was freeze a specific date, and the date it froze was the date of the closing and products that were sold or installed before that date. And what the contract said, both in the whereas clause, where a specific assumption of all those liabilities, in a definition of liabilities, and most specifically in the section of the contract and the specific buyer's undertaking, where it specifically stated that the buyer does assume and agree to pay all obligations, liability, debts, and commitments, fixed or contingent, connected to Kiwani, existing and outstanding the date, including by way of specification but not limitation. And the warranty, service, repair, and return obligations of Kiwani and other claims and complaints arising out of or in connection with any products manufactured, sold, leased, or installed by Kiwani on the date prior hereof. It was an assumption of all claims that would relate to Kiwani boilers going forward. And indeed, Your Honor, that is the interpretation that has been found by courts for 30 years, beginning in 1980, 2 cases. OFABCO was a part of those cases where the court issued that same interpretation.
What about Grant Howard? What's the difference between these two?
Critical difference. First difference is the business transaction. The OFABCO American Standard was the purchase of assets with a specific assumption of liabilities. An asset sale, the parties will agree as to what the exact assumption or non-assumption of liabilities. That's the deal term. Affected the price, affected OFABCO receiving the receivables, and the other terms of the agreement.
If existing and outstanding at the date hereof was not in there, this would be a much stronger contract for you, wouldn't it?
No, it would be exactly the same, because at the date hereof, the duty to warn was existing and outstanding. And when you take a look at the thousands of asbestos complaints, all those complaints, or most of those complaints, I don't want to overstate, have a duty to warn claim.
But none of those existed at the time.
The obligation of a duty to warn existed at the time.
No, none of the claims existed. No one knew about asbestos back then. And if
The litigation, the way we know it, started after
If
that.
it said all obligations, liabilities, debts, and commitments, fixed or contingent, connected with or attributable to Kiwani, including by way of specification but not limitation the following, it would seem to me that there'd be less issue as to what contingent liabilities were. But because it says existing and outstanding, it almost reads like an asset purchase agreement.
And it was an asset purchase agreement. That's exactly what it was.
But no, because both of you seem to agree that it's lock, stock, and barrel. It's everything. And it seems to me, if you just buy the assets, you're leaving the liabilities over here.
It wasn't, and that's correct, other than the parties' explicit negotiation, and the business term was a negotiation that the buyer have a full and complete assumption, including an undertaking that was signed in conjunction with the transaction. And that was the business terms that affected the entire transaction. Grant Howard was a stock sale.
Right.
And in Grant Howard, not only is the language completely different, which is set forth in a detailed chart in our brief, but in that transaction, the seller of the stock sold the stock, and normally that would mean that the seller would have no liabilities. But in that situation, there was the contract provided that the seller agreed to assume certain liabilities nonetheless. Explicit liabilities, the language says it's limited to only the explicit liabilities that were assumed. And that's and the language.
Can I ask you, what entitles you to the injunction against their relitigating the issue?
I'm sorry, I didn't hear you.
I wanted to ask you, was the court right to give you an injunction against their ever taking a contrary position again? Isn't that kind of unusual?
The court was absolutely correct. What's unusual is what's happened here factually. This is a case where for the first 30 years of the litigation, Oak Fabco had the ample opportunity to litigate. It began in state court.
Okay, but even fairly persistent litigants you don't usually get enjoined from ever making the same argument again. Isn't that a pretty extreme remedy?
It's extreme because, Oak Fabco went on a pattern after 30 years of being told what the contract meant and abiding by it and taking advantage of the contract interpretation through a bankruptcy proceeding which allowed it to be able to discharge.
Okay, and then they were so persistent they even won a couple after in Oklahoma and Washington.
And what they did was pick cases where American Standard was not a party and submit incomplete records. And when
but still, basically, don't they essentially have the right under the First Amendment to tell a judge what they think a contract means? The judge doesn't have to agree with them. The judge can say it's res judicata, but it's pretty extreme to say you can't make the argument. If you submit a brief to a court in Illinois or Hawaii, you're in contempt of a New York court?
In light of the course of conduct here and the pattern of submitting...
Where's the irreparable harm?
The irreparable harm is that we are dealing with thousands of cases across the country in many jurisdictions. Some cases were a party, some cases Oak Fabco, and some both parties aren't a party. Because the indemnification obligation that Oak Fabco had to American Standard was discharged in the bankruptcy, there's no way that we can be made whole from an economic remedy.
Why are you suing? That puzzles me. Why are you suing on an obligation that's discharged?
We're not suing on the indemnification obligation. That's been discharged. We are suing on the assumption of liability obligation. And Oak Fabco has taken the position, as it has here.
You say that the discharge in bankruptcy does not apply, that if you win this case, they're on the hook for every dime?
No, that's not correct, Your Honor. We have not argued that the discharge of the indemnification obligation does not apply. There was a ruling by Judge Schmetterer. We've litigated that, and Judge Schmetterer found that that was extinguished in the bankruptcy, except American Standard has a right to pursue Oak Fabco's insurance carriers.
Okay. Is there anything at stake for your client in this litigation or other than those insurance proceeds?
Absolutely, Your Honor. We are faced with litigations where OFAPCO is...
You want to have some company in that litigation, is that what it comes down to?
Well,
You want another deep pocket next to you?
Well, that's a party that's assumed those liabilities and has a contractual liability for those for those obligations and has judicial
I mean, you're putting it more delicately than I did, but it's the same thing, isn't it?
Yes, Your Honor. I was trying to be a little more polite about it. You asked further, why do we need that? During the argument in the appellate division, FAPCO's counsel was asked, would they abide by a determination, obviously res judicata between the two parties here, as to the meaning of the contract, or would they attempt to relitigate it in other courts? And the answer was they would attempt to relitigate it. This Court has...
So if we gave you a declaration, if we were to affirm the appellate division to the extent of declaring that in fact they assume this third-party tort liability, ad infinitum, but reverse them on the injunction, you would not have complete relief? We can't assume that they would abide by
That's
declaration?
correct. That's correct. They've already had declarations as to what the contract means. That we had two cases in the 1980s to that effect.
Is there any precedent for an injunction like this?
This Court has broad powers to issue an injunction.
Can you answer that with, give me an answer with a V in the name?
The answer is, I don't think I have ever seen a case where a party through 40 years of litigation, numerous decisions interpreting an agreement, and they continue nonetheless to try to relitigate it and relitigate that agreement under incomplete records, where you have an overlay of a national mass tort where the same issues come up in multiple jurisdictions and multiple times. The only way one can have some type of finality and assurance as to the agreement between the two parties is to have a declaration as to the contract, as well as an injunction that says, finally, enough is enough. You mentioned the Smith case, Your Honor, which I thought I did in your facts, a 1952 boiler that was manufactured in 1952 and that exploded in the 1970s. It was in front of Judge Schmetterer, and it was post-bankruptcy, and OFAPCO went to Judge Schmetterer and said, we would like to have a finding that our assumption of liabilities for that type of boiler explosion should be discharged post-bankruptcy because we have completed the bankruptcy process. Judge Schmetterer said, I will not discharge that obligation because you didn't establish
And then they passed up the chance to say we never took this liability from American Standard in the first place.
That's correct.
But I mean, I understand what you're saying, but is it not true that if you win this case and you get the declaratory judgment you're asking for here, you have a stronger res judicata argument in future cases than the one you're making to us?
But then what we have to do is to keep in track of every case across the country where this is raised, where we're not a party, and go into that court and say, this is the declaration, and you should enforce it, as compared to the New York court that has the power to enforce its own decision.
Maybe you could just make sure that the world of asbestos plaintiffs learns about the declaratory judgment, and they'll take care of that for you.
Well, maybe that presumes they're happy with just the payment for one party and not two parties. But putting that aside on that basis, but it is an appropriate method of enforcing this holding. Res judicata should be enough to be held over the head of a litigant and say, wait a minute, I already have had a final determination. I will abide by the rule of law. They haven't abided by the rule of law up to this point. We have reached the point that if Your Honors affirm the interpretation of the agreement, I ask, I was going to say beg, but that's probably a little bit too poetic for my style, that you issue the injunction that was issued by the court below, by the appellate division. It is as narrow of an injunction as possible to provide the relief that would be appropriate here. It is basically stating that, very limited, that in light of a long history of litigating this matter in many states, and in order to give plaintiff complete relief, defendant is enjoined permanently from relitigating whether it assumed liability to plaintiffs injured by Kewanee boilers sold or installed before 1970. That's the only relief. Plaintiff, FABCO can make whatever argument it wishes in the underlying cases as to whether or not there's causation, product ID, and any other argument it can, but it cannot make that argument.
Okay. Thank you, counsel. Counsel Rebella.
Let me address the story they keep wanting to tell about the long history of litigation and what our motive is. There were two cases, one in 1980, one in 1984, involving individual claims. We don't know anything about the facts. We don't know anything about the legal analysis in those cases. That's it. Then we get to the 1990s when they go into bankruptcy court. They only came into bankruptcy court because we filed to show the potential creditors in the form of the third-party plaintiffs. In the course of doing that, we laid out for the court, we also have contribution claims from a ton of people. And there is American Standard. So American Standard comes in, and they say, okay, we want to get we want to litigate our right to 17 claims, and we want to litigate our claims in the future. So they had a vehicle right then in the bankruptcy court if they really wanted a declaration that wasn't specific to two individual claims, one in Minnesota and one in, I don't even remember the state, New Jersey, but to cover broadly any all past, present, and future claims, actually present and future claims. They didn't do it. They wound up walking away from that claim. And the fact of the matter is the only reason they got the decision against them and the bar against them in bankruptcy was because they voluntarily came in. If they'd come in and objected and say, you can't bring us in now because you didn't give us notice way back when the case started, then the court would not have discharged them in bankruptcy. The Smith case that they talk about is a case that was decided in the bankruptcy court not based having anything to do with our contract with FABCO, I'm sorry, with American Standard. It had to do with the bankruptcy law and whether, in fact, you could discharge a plaintiff who never got notice of the bankruptcy.
But it is true. I mean, this is not on the point you're making now, but on the point we're discussing earlier. If you're right on what the contract means, you had a complete defense to the Smith case that you did not assert.
But it wasn't something to be asserted in the bankruptcy court.
Forget about the bankruptcy court. Smith would have been dismissed.
No, but the point is that was an issue to be litigated in the state of Maine in the state court.
Did you litigate it?
I don't know. It's not in the record. I mean, that's the honest answer. I just don't know.
What about the injunction?
Oh, that injunction.
Well, I'm sure you don't like it, but why, if we find against you, should we not?
We have very much the same concerns that Judge Smith has articulated. You look at that and you say, why isn't it enough to give a declaration that is going to be abiding?
Why do they have to chase you around the country?
They didn't have to chase us around, Your Honor.
I'm saying in the future.
If there is a published decision that's a declaration, then that's going to give them the protection they need. If it turns out that it's not,
well, you're
that we still...
You're not going to waive our decision in these other states?
We have certainly an obligation to acknowledge the binding decision of the New York court. And by the way, I was the person that was in the appellate division that was asked the question, and I don't believe I said anything remotely like what opposing counsel said. Unfortunately, we don't have a record, but I do want to represent to you that we've never said we're not going to fail to abide by a binding declaration by this court.
Okay, counsel.
Thank you very much.
Thank you
Appreciate
both.
the time.